Justice of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business before this court or draw near and give their attendance, and they shall be heard.
Thank you. Please be seated. The first case on for argument today is People versus Trisvan, case 274. Counsel, proceed.
Good morning, Your Honors. Stephanie Stair for Mr. Trisvan. Unless there are any questions, I will rely on my brief.
Very good. Thank you, Counsel.
Thank you.
Good morning, Your Honors. Ryan Ash for the People, and likewise, if there are not any questions, I will rest on my brief.
Thank you, Counsel.
Thank you.
Case 275, People versus Thomas. Counsel Waldman.
Good morning, Your Honor.
We can hear you. Can you hear us?
Yes, I can hear you.
Very good. Please proceed.
Regarding point 1, timing matters. The people are conflating the following. The plea offer, where county court made one passing reference to the appeal waiver, defense counsel's one sentence about the appeal waiver applying to the suppression issue, the plea colloquy, Mr. Thomas's plea allocution, the judge's conclusion that the plea was knowing, voluntary, and intelligent, and the model colloquy of the appeal waiver. These are not to be lumped together and analyzed as one thing. They are discrete portions of the proceeding in which timing of each part matters. I can see that the substance of the appeal colloquy was adequate. However, it is the timing of that colloquy with respect to the other parts of the whole that makes the appeal waiver not knowing, voluntary, and intelligent. The people cite to Bryant and Roadhead Fox, but those were decided before Thomas. Before pleading guilty, county court never explained the waiver, and it is not defense counsel's responsibility to explain the waiver to him, but trial counsel's responsibility. The plea proceeding was effectively over after Mr. Thomas allocated to the crime, and county court found his plea knowing, voluntary, and intelligent. So the instant case is equivalent to the cases where the appeal waiver is not raised until sentencing. I ask that the court apply those cases here. Regarding point 2, there was no reasonable suspicion to stop the vehicle. I request that the panel uphold its precedent in co-defendant McMillan's case. Even though that case was dismissed because the
That's what I was going to say. That case was dismissed. I believe that there was a death, correct?
Correct.
And so I don't think you can really use that at the moment.
I think that the reasoning and the holding, however, in that case should apply to the instant one, because the facts in Thomas's case are identical in all material respects to Mr. Thomas's case. When Deputy Bresentine told officers to effectuate the stop, he was acting on a hunch and had no concrete evidence of criminal behavior. There were no reports.
If we find the waiver was valid, then we don't have to go into any of this, correct?
Correct, Your Honor, but I'm hoping that you find that the waiver was valid. There were no reports of any larcenies. Bresentine admitted that it was not illegal to bring bags from other stores into the mall or place merchandise in your own bags. Although he was watching the surveillance video in real time outside of Justice, he could not see what was going on in the store. Mr. Thomas was in the store for 5 to 13 minutes, and Bresentine admitted that it was possible to purchase merchandise in that amount of time. No one ever saw Mr. Thomas or his co-defendants conceal merchandise, and they walked out of the mall calmly. Behavior that is equivocal or innocuous is open to both innocent and culpable interpretation and cannot form the basis of reasonable suspicion. All of the behavior I listed is equivocal, and even the totality of equivocal behavior does not transform that behavior into reasonable suspicion. Bresentine's after-the-fact observations like the Victoria's Secret video cannot go back in time and create reasonable suspicion. There would be no plain view if the vehicle was not illegally stopped. Therefore, all of the physical evidence in Mr. Thomas's statements must be suppressed as fruit of the poisonous tree.
We'll take a hard look at that, counsel, your second point.
Thank you. Unless there are other questions, I rest on my brief.
Thank you.
Morning, Your Honors. Kaylin Porter on behalf of the people.
I'm sure you're going to say that the waiver was valid, so why are you?
Correct. So we have a thorough waiver here. Counsel even acknowledges in the brief that it followed the model colloquy. To the extent that counsel is now contesting timing, as raised today, the legal colloquy happened, the factual colloquy happened, and then immediately the court went into the waiver of appeal colloquy. So to the extent that it's timing, counsel relies on cases where this was sort of a gratuitous condition that was tacked on at the end, or...
And it's different than with sentencing.
Correct.
Where there's a period of delay.
Correct.
Right?
Or just never even mentioned as a condition of the plea agreement. That's not what we have here. It's very expressly mentioned as a condition of the plea agreement. So I don't even think we reach the issue because the defendant expressly waived this condition. As for just the substantive argument, counsel asked this court to uphold its precedent. That's a vacated decision, so it really doesn't bear any weight on this court's decision today. And as for the fact that it's identical facts, well, presumably it would come out similarly. It was still a separate hearing. This defendant did have a different hearing. Just one fact based on the vacated decision that was articulated was that the deputy acknowledged that it would have been possible within 5 minutes to make these purchases. Whereas the testimony here, counsel seemed to be going with an angle that the defendant was in the store for 13 minutes, and he acknowledged that it would have been possible to make those purchases within 13 minutes. So that's the only acknowledgement that we have to the possibility there, but even so, the deputy did say that he was only in the store for 5 minutes. So unless there are any questions from the court regarding the substantive points or the waiver of appeal, I'll rest my case.
Thank you, counsel.
Thank you.
Next case up for argument is case 282 in the matter of Jaden M. Very good. Counsel Azella, can you hear us?
Yes, Your Honor.
And we can hear you. Counsel Considine, can you hear us?
Yes, Your Honor, thank you.
Very good. Counsel, proceed.
Good morning. Thank you, and may it please the court. My name is Stephen Salcedo. I represent the appellant in this case. The appellant is the father of the subject child. A petition to terminate father's parental rights was brought. The case eventually proceeded to a fact-finding hearing. My client did not attend the fact-finding hearing. His family court attorney requested an adjournment. That request was denied. The court proceeded to hold the fact-finding hearing, did not hold a dispositional hearing, and it terminated my client's parental rights that same day. My client's family court attorney chose to remain silent during the proceedings, and so he did not object or cross-examine or otherwise participate.
Does that make it entered on a default?
Your Honor, the default issue, I believe, is relevant only to the substance of whether the agency sustained its burden on the TPR. I don't think it's relevant to whether an adjournment should have been granted, which is another claim that we've brought up on appeal, in addition to the lack of a dispositional hearing. With respect to the default, though, it is an issue that, in my view, is not so clear in this department. There's some case law in the AFC's brief and in DSS's brief that I acknowledge seem to weigh against me, seem to suggest that this was a default, particularly where the attorney remains silent. However, there is case law suggesting and indicating that from this department that it was not a default. I've also cited treatises in my reply brief indicating that, at least according to whoever's writing those treatises, they believe that this situation does not constitute a default. And so I'm asking the court to sort of resolve this uncertainty and to side with the two-judge dissent in the Ireland case, which the AFC cited in her answering brief. It was a dissent, but the 5 judges in the majority did not weigh in on the question. They concluded that the question wasn't raised before the Court of Appeals, and so the only 2 Court of Appeals judges to weigh in on that question Judges Rivera and Wilson determined that in this situation, it's not a default because clients may appear through their attorneys under the CPLR. I believe it's CPLR 321. My client's attorney was there. He did not withdraw from the case, and so my client effectively was present. Additionally,
So you're saying that by being present, even if the attorney takes the position with the court that I'm not participating, that it's not a default because they're physically present in the courtroom?
yes, Your Honor, because they're physically present and because they did not withdraw from the case, and so Mr.
That does go against what our holdings in the court department.
I have seen in the briefs holdings that go against what I've just said, and I've seen holdings that I've cited in the briefs that support what I've said. And so my position is that there is some uncertainty, even among members of the bar, and that the issue should be resolved clearly, so at the very least, moving forward, we know what is a default and what is not in family court matters.
One of the issues Judge Rivera indicated in the dissent, or one of the points that she made, is that the appellant had no obligation to present proof, that the DCFS in that case had the burden. Same is true here.
Same is true here. My client could have appeared, and even so, he could have remained silent. He could have chosen not to participate. In theory, the lawyer might not have objected to anything or cross-examined anyone. It's the burden of the agency. In this case, my client didn't have to put on any proof. That's correct.
On the timeliness issue, your position is the only evidence in the record is that the order was emailed and that's properly served, therefore there's not a timeliness issue relative to the appeal. Is that right?
We have three arguments on timeliness. The first is that the order needs to be mailed to my client and not simply to my client's attorney. There are two prior orders in this case, and I think I even put screenshots in my opening brief, where the order lists at the end all of the recipients of that order in the mail, and my client's name was listed on those first two orders. This order, the one that's on appeal, the only names are the attorneys. So I think there's a clear implication that this order was not mailed to my client himself. Further, my client's attorney says it wasn't even mailed to him. That's in the affidavit, or in the notice of appeal. He says this was actually emailed to me. Under this court's precedent, I believe it's Grayson from 2022, emailing the order is not sufficient. It has to be mailed to start that 30 or 35-day clock.
Thank you, counsel. Anything further?
I just wanted to emphasize the lack of a dispositional hearing in this case. I don't think there can be much dispute that under Family Court Act Section 625, a dispositional hearing must be held. But the key question, I think, for this court today is whether it can reach the issue, because as I've said, my client's family court attorney did not object to anything below, including the lack of a dispositional hearing. As I state in my reply brief, there's two reasons why this court should reach the issue and remand this case at a minimum for a dispositional hearing. The first is that, as this court indicated in the Brian W. case that I cite, it's from 1993, and a few others, this is not a defect that needs to be raised at the family court level or needs to be objected to. It's akin to a motive proceedings error. This is a procedural step that's required in the Family Court Act, and so for that reason, this court should reach the issue notwithstanding the lack of objection. But if this court disagrees with me on that, then of course this court has interest of justice jurisdiction and has exercised that jurisdiction before when necessary to promote or to ascertain the best interests of the child. And if this court remands for a dispositional hearing, the purpose of that hearing is to ascertain the best interests of the child. And so for either of those two reasons, this court should reach the issue and at a minimum remand this case for a dispositional hearing, which was not held. And if there are no questions about that or any other issue, I will rest on my briefs.
Thank you, counsel.
Thank you.
Counsel Ozella?
Yes, Your Honor, Madison Ozella on behalf of the Erie County Department of Social Services. I would first start with the issue that this was a default. While I agree with counsel that there are some different court decisions on what constitutes a default out of the Fourth Department, I think the vast majority of the decisions this court has issued does indicate that when the respondent fails to appear and the counsel sits silent, that it does constitute a default. There was case law submitted by the appellant's attorney. However, in that matter, the litigant had missed a court appearance. It was not a trial date certain as it was in this matter. So I think this was a default, therefore appeal should not have been taken. If the appellant had a meritorious defense and reasonable excuse, this could have been addressed at the lower court with a motion. That is the point of counsel sitting silent as opposed to proceeding in their client's absence, to give them that opportunity to address their absence with the court and be able to participate in their own defense. So I think this matter should not even have made it this far, so I would
What
stop
about
there.
the, what about the argument that an adjournment was, the lack of an adjournment being granted was an abuse of discretion?
So I think the court has been clear on that the issue of whether or not an adjournment should be granted is within the sound discretion of the trial court. And while I acknowledge the parents have significant rights, the rights of the children are also paramount in family court. This child had been in foster care for almost his entire life. At that point, we were about 3 years in at the time of the trial. So this child had a right, just as Mr. Maldonado had a right to appear in these proceedings. The difference is the parent waived his right to participate. That child's ongoing right to permanency maintains, and the lower court did not abuse its discretion in declining that adjournment request. Beyond that, as counsel indicated, the department's obligation to meet the standard, and here there is ample testimony that supports the lower court's finding of termination. I understand the issue of the dispositional hearing. However, I would indicate the record is rife with information that would have been elicited at a dispositional hearing. The point of that hearing is to make sure the court is aware of where things stand now, to be able to make that best interest determination. As indicated in the record, Judge Lavallo indicated she was able to piece out what goes to fact finding, what went to disposition, as testimony was offered up to that time as to what the respondent had engaged in, how the children were doing and the child was doing in his placement, and things along those lines. So while there was not a pause essentially between the finding of permanent neglect and the decision to terminate, the court had testimony provided to determination of the child's best interest, and use that in making its determination to terminate the parent's parental rights. So I would ask the lower court's decision be affirmed.
Thank you, counsel.
Thank you.
Counsel Considine?
Good morning, Your Honors. May it please the court. My name is Rebecca Considine. I represent the child in this matter. I'm of counsel to the Legal Aid Bureau of Buffalo. For the majority of my argument, I'll rest on my brief unless the court has specific questions. I would, however, like to offer an update on how the child is doing presently. The child is 5. He will be 6 in April. As Ms. Ozella indicated, this is a child who was removed from his parents' care at the age of 7 months and has been outside of the home to date. He was freed in September of 2023. The TPR petitions were filed a year prior to that. So I cannot emphasize enough the amount of time that this child has spent in care. Since I guess I would say that the record before the court certainly indicates the child has had a history of instability and inconsistency. One of the things that's highlighted in the transcript is the inconsistency of the respondent in visitation. Since this child has been freed, he has made an insurmountable amount of progress across the board. His custodians presently are ensuring that he is in counseling. They are engaged in PCIT, which is parent-child interaction therapy, to make sure they're meeting his needs. All of his school needs are met. The one thing that I would like to highlight is the relationship he has with all of his siblings, which has continued to date. There is a half sibling in the home that is also freed for adoption, but outside of that, the mother has another child, and there's another half sibling that were born after this case came. And my client has regular and frequent contact with not only the mother, but with those half siblings. Also, there's siblings in Florida that he has frequent and at least virtual access with them. So across the board, he is just doing phenomenally well. I think the stability and consistency for him has made a huge deal in terms of progressing. One of the things I would say is that counsel indicated that the best interest of the child is what's considered, and he is asking for this to be remitted and have a dispositional hearing. At this point, I think there was testimony in the record indicating his progress post-filing. Certainly the court did make note of that. I did not request a dispositional hearing, and again, counsel for the respondent at the time thanked the court but did not make any specific objection in terms of not holding that hearing. This is a trial that lasted an entire day. At no point did the respondent show up. I believe the transcript also indicates that counsel indicated he spoke to the respondent in the morning. There was not anything offered other than transportation as a barrier, and the record also reflects that transportation was offered for him that day. So given all of those things, it is in the best interest of my client to have permanency. Again, he is almost 6 years old, and I would ask that the court uphold the finding. Thank you.
Thank you, counsel. Case 283-284, in the matter of Chandler W. Counsel, can you hear us?
I can, Judge. Can you hear me?
We can. Very good. Proceed.
The Department of Social Services in this case established both child abuse and derivative child abuse by a preponderance of the evidence. The multiple bone fractures in the 5-month-old who was a non-cruising infant were found to be both non-accidental and indicative of child abuse by the treating professional at Children's Hospital. Additionally, the daycare providers believably testified regarding the morning that the child presented with the injuries. They described Chandler as normally a happy baby. He was distressed as soon as he got there early in the morning and eventually became absolutely inconsolable. It was when they noticed this behavior, in addition to the substantial bruising all around the torso, that they called for an ambulance for emergency medical care. Additionally, the mother failed to rebut the statutory presumption of parental responsibility as allowed by statute. Unless this court has any further questions, I'll rest on my papers.
Very good. Thank you, counsel.
Thank you, Judge.
Case 285, Tiedemann versus Salerno. Counsel DePasquale, can you hear us?
Yes, Your Honor. Can you hear me?
We can hear you loud and clear. Please proceed.
Thank you. May it please the court and counsel. I'll rest on my brief relative to the argument as it pertains to the CPLR 3211A1 and A7 positions. I'd like to focus most of my attention on the summary judgment and why the lower court committed reversible error in deciding the matter on summary judgment. Your Honors, I think this matter and this record shows that it is replete with tribal issues of fact, particularly as it pertains to whether or not the respondent committed fraud in the inducement and did intend to comply and mean what she said in not obtaining a divorce or otherwise terminating their postnuptial agreement. That was the consideration for entering into it. You see in the record through her testimony, through phone records, that she was in contact at least 9 times with a realtor, the execution of the agreement which was prepared by her attorney, not by attorney Sanchez, who had a limited involvement, as the record shows, with the appellant, sent one letter and just briefly talked to him, but she had substantial contact with realtors. She purchased and entered into a contract to purchase a house prior to entering into this agreement. She talked to a mortgage broker, all in phone records that was established in the record in response to the summary judgment motion. And as this court recently held in December of 2023 in the Sleeman matter, which was an equally voluminous record pertaining in that case to a prenuptial agreement, matters of fraud, duress, coercion, overreaching should be determined after a hearing and not by way of summary judgment as this was. So that's issue one.
Counselor, we start here with the presumption, don't we, that these agreements are generally enforced?
You do, Your Honor.
We do, and here there was the motion for summary judgment, and do you disagree that the burden shifted to your client to raise a question of fact here? You agree?
I agree with that, Your Honor.
And so the response to a lot of these allegations from the former wife is that she only began the divorce proceedings when she found out about the fact that your client was using the Tinder app after they were engaged in counseling.
Shows that that Mr. Tiedeman's, the appellant's response to that was contradictory, and he didn't use that app until September of 2019, and not during the time in which they were trying to reconcile. I also think that the evidence that was proffered by the respondent for summary judgment, it relies on two particular pieces of evidence. One was an appraisal by Strell, we'll call the Strell appraisal, which was an unsanctioned appraisal. It was done in violation of a 2022 order by Judge Ogden, where she denied the respondent's request for a further appraisal. Then, when the matter was transferred from Judge Ogden to the present judge in November of 2022, she went on her own outside in violation of that order to get that appraisal, which was a drive-by appraisal. So that is not a sanctioned appraisal. The second piece of evidence that she relied on was one letter from Attorney Sanchez. There's no file, there's nothing else but that letter to establish her summary judgment claim. It was rebutted by the appellant with numerous pieces of admissible evidence, not just the entire testimony from the parties' EBTs. There's a forensic accounting done by Mr. Ayer in 2021 showing a $189,000 fraud that he breaks down. There's appraisals that were sanctioned and proper too that were submitted by the appellant. One for $645,000, which was in and around the agreement was executed, and then the Alden State Bank appraisal. There were phone records submitted by the appellant showing that the respondent was in constant contact, 9 calls to a realtor before they entered into that. So there were...
Counsel, could I, now that you brought that up again, could I just ask you about this? I see in the agreement that there's a representation that there's no present intent to divorce. And that's sort of the language it seems that you're grabbing hold of, saying that, well, gee, we think that there was, based on these phone calls to the realtor and other evidence that you've presented. It strikes me that, you know, your client, and you made mention of Mr. Sanchez. It seemed to me that whatever he asked Mr. Sanchez to make sure was in the agreement, Mr. Sanchez advocated for him. So I don't know if I agree with you necessarily on Mr. Sanchez's limited role, but was there anything that prevented your client from saying, you know, in the event that you file for divorce within a certain period of time or by a certain date, the agreement's void, so that he could basically put into writing what he claims now is his concern at the time was that, gee, you know, I want to make sure that we're not going to sign this and then you're going to divorce me tomorrow. Anything preventing him from putting that kind of language in the agreement?
There's not, Judge, and I think that this, and I think it was referenced in the papers below by the appellant's attorney, that this case is analogous to the O'Malley case from the Second Department that contained a similar clause. And because of the heightened scrutiny that this court, that the Court of Appeals and all the courts in this state give to matrimonial agreements, that when it comes to whether or not equity should intervene to set it aside, whether it comes to whether or not there was a true intent by the respondent to comply with this provision and not engage in divorce proceedings, that should be ferreted out at an evidentiary hearing and not by a summary judgment motion to determine the entire circumstances surrounding the execution of the agreement and in the agreement on its face, other than the agreed upon value of the marital residence. There's no values for anything listed. There's no income information listed. There is a severability clause, again, I should point out, as to whether or not parts of the agreement are thrown out or the entire agreement is thrown out. But if you look at the agreement just on its four corners, it is difficult to ascertain values or whether or not there's any benefit to the appellant for paying what is an astronomical sum of spousal support, well beyond what the cap would have been, as noted in the papers below. So we think it's reversible error on multiple fronts. It should at least warrant a hearing and not be decided on a summary fashion. I think that's
Counsel, I think we have that part of your argument. Is there anything further?
nothing, Judge. Thank you.
Thank you, counsel.
Good morning. May it please the court, Justin White, appearing on behalf of the respondent. I think one of the important pieces of this puzzle is the memo that Mr. Tiedemann made to himself that appears at the record at 237, where he sat down with a pen and paper and mapped out the terms, the financial terms of the underlying agreement, how much money the house on Billow Road was worth, how much his practice may have been worth, all the issues that now suddenly Mr. DePasquale wants to bring up were intelligently and protractedly considered by the entrant to the agreement. Mr. Tiedemann was well aware of what he was doing, and I think what we're looking at here is simply an instance of...
The parties were represented by competent counsel all throughout this process.
That's correct, sir. If there's nothing further, no further questions, I rest.
Thank you, counsel.
Thank you for your time today.
Case 286 in the matter of Hanselise S. Very good. Counsel Whiteside, can you hear us?
I can. Can you hear me?
Very good. Thank you. We can. Counsel Gray?
Yes.
Very good. We can hear you too. Please proceed.
Thank you, Your Honor. My name is Mary Whiteside, and I'm representing the Monroe County Department of Human Services of counsel. I'm going to ask that you uphold the family court's determination that the appellant violated the judgment. Workers provided credible testimony, and their documentary proof of this was overwhelming, was largely unrefuted. At the dispositional hearing, the appellant had not completed his sex offender treatment, mental health treatment. He had a new significant mental health diagnosis. His in-person visits, which were at the highest level of care and supervision, had been suspended for safety because of threats, which he admitted to that he made to staff. The appellant never argued any extraordinary circumstances, didn't request an extension. He argued that he thought he complied with a summary judgment order. In contrast, this child who has suffered really an amazing amount of abuse and neglect in her life, she's happy, she's stable in her kinship pre-adoptive foster home. This was relatives who became certified foster parents. They would like to adopt her. It's a stable, loving home environment. They provide for all of her needs. And she deserves this permanency, and I ask that you uphold that so that she may be free for adoption. And I'm happy to take any questions if you have any.
No questions, counsel. Thank you.
Thank you.
Counsel, proceed.
Thank you, Your Honors. I support the legal arguments set forth by Ms. Whiteside and would just like to update the court on how Hanselise is doing. Next month, she will be 15 years old. She's very happy in her kinship placement. She wants to be adopted. She's doing well in school. She's continuing in counseling. So if the court doesn't have any further questions, I would rest on my brief.
Thank you, counsel.
Thank you.
Case 289, Kathy G. versus Erie County. .289 and 290. Counsel, can you hear us?
Stuart Marmelstein, I can hear you, yes.
Very good, thank you. We can hear you. Counsel, proceed.
Okay, thank you, Your Honor. James Special for Child and Family Services. So obviously, as you know, we have a statute of limitations issue here. And I think the first thing I need to talk about, because it is such a big deal, is this court's case in AS. The problem I have with that is when I went to read the record in that case, in my view, plaintiff never really had 1024 as a remedy in that case, because to utilize it, you're supposed to you're either supposed to find out the John Doe prior to the expiration of the statute of limitations, and if you don't, you're supposed to move pursuant to 306B, which he didn't. He didn't move until after. So to me, that's why 1024 should have never come into play in that case, or in this one too. I think we're just looking at 203 and the relation back doctrine therein. So, and the problem I have with that is, when you look at it that way, I don't think we're united in interest with the county.
Before we get there, Counselor, I just want to make sure I got the record straight in my head. Do you agree that in response to your motion, the plaintiff argued specifically reliance upon 1024?
In this case, yes.
So 1024, you would agree, is an issue that's clearly preserved for our review, and it's something that we're going to have to address. I know you're shifting over to the relation back doctrine, but I'm still stuck on 1024. Do you agree that that is something like in AS? We could, if we went with the plaintiff, we could simply do AS and say 1024 is satisfied, and we don't need to do relation back. But then, no matter what, we have to deal with 1024. Would you agree?
Well, yes, but I would agree in two ways, actually. So, I mean, the point of, so 1024 only came up in this case because of AS. When I moved, I had not read that case. They brought it up, right? So, and then when I went to read AS, I thought, well, I believe it to be wrong because the 306B motion wasn't made till after the statute of limitations. So yes, you have to deal with 1024, but you only have to deal with it, I think, because you dealt with it in AS. But I think AS is wrong, if that makes sense.
Well, right, no, go. You first, please.
Just to play out what occurred here. The plaintiff, your argument, the plaintiff should have made the motion under 306B within the 120-day period that they had under essentially through 1024 in order to identify the Doe defendants. You couldn't identify them during the 120 days. You got to make your motion.
Yeah.
They didn't make the motion. They had the stipulation. We have the stipulation in the record. Putting the stipulation aside for just a second. Had your client argued at oral argument, hey, you never made the motion, perhaps plaintiff says, well, I'm going to cross move now. I'll make the motion now. And then you're in it. Then you're in the issue below. And then the court's saying, well, can you do it after the fact? You can make all the arguments you're making. But that wasn't done below.
So, okay. So the problem that we would have ran into doing it then, I agree with you that best case, that would have been great to do, but the problem is that AS was out there by then, and the decision, and when I went through the record, it's like, well, 306B wasn't an issue in that case, so it seemed like we were done on that, you know?
Well, the question is, did you waive it? Because had you challenged it at the time, and then, you know, the response is, well, but AS says that we can do it after the fact. Well, at least you preserve the issue then. At least you've gotten the response. The question is, was the issue even preserved?
Well, to that end, I mentioned it briefly in the reply. My view on that is because they brought it up, then it's fair game. Because, like I said, I didn't know about AS. In my mind, we're looking at 203, and then they bring up AS. And one issue is with a reply affirmation, as you know, you get like 2 days. So I'm writing the thing. I'm looking through AS, it's the record and all the briefs, and I got like a day and a half to do this. And then then as I went on with that and I learned more and more, I realized, okay, well, this is incorrect. So I think it's fair game because they brought it up. They relied on their.
And Counselor, we all practiced law before we got here, so we're
Yeah,
not
no,
going to find fault or thing. But in fairness, and our rules require that an argument be preserved at Supreme Court. And I have to tell you that I searched. I did a word search. I tried to read everything. I found no mention in your papers of 306B at all.
Right.
And under the case law, as I understand it, 306B is essentially an argument under 3211A8, having to do with personal jurisdiction. And if you do not raise it in your motion, it's gone. And in your motion to dismiss, you didn't raise it. So that's really the struggle we have. And if we address it, it's almost like we're overlooking the fact that you didn't move on those grounds. I also look for the argument. Again, I'm not looking to find fault. I remember how hard it is to practice law. I really do. But I kind of look for an argument and say, hey, wait a second, this stipulation isn't good enough here, because here the plaintiff didn't even do what they did in AS. In AS, they actually sought relief under 1024. Here, it just says we're adding a new party. Well, that's different than 1024. If you add somebody new, then it's only relation back. But none of that argument, Counselor, is there, and it just seems to me to be entirely unfair to the plaintiff to now address it on appeal when it's not preserved below. That's really what I'm struggling at. Do you agree that it's not preserved below under 306B and that you may have waived it?
So yes, I would give you the preservation. I would disagree on waiver though, because, well, for one, I think it's, like I said, I think it's fair game because they raised it. But two, when we go to the second prong of 1024, it's due diligence, right? So I actually think you could ultimately get to the same conclusion, and not dealing with that issue at all, if that makes sense.
We still have to look at 1024 to see whether or not the plaintiff can rely on it. But the question is, does 306B defeat the reliance? And if it's not preserved below, you've already heard me say this, that's really what, at least for my part, what I'm struggling with. And I appreciate your candor and your argument very much.
Sure. Yeah, it is a difficult issue, and in AS2, he didn't raise that, which I'm guessing is why, it could be why the case turned out it did. But the problem I have with it is that it's out there and it's being used, and I think it's wrong. So
I think you made that pretty clear. I thought it was wrong.
Counsel, we have your argument. Any further?
So actually, on the second prong.
Briefly.
Yeah, briefly. On 1024, you have to show due diligence, and I don't really think they did here prior to the expiration of the statute. And if there are no further questions.
Thank you, Counsel.
Counsel, proceed. May it please the court, Stuart Mermelstein for the plaintiff respondent. I'd like to address the point made by the attorney for appellant that the request for records here is somehow different from the request that was made in the AS case. They're materially the same. They're both pursuant to Administrative Regulation 428.8, which is the means by which a foster child can obtain their foster care records. And it's a detailed administrative regulation as to be requested and what's required to be produced by an authorized agency. And in this case, the request was submitted to the authorized agency, Erie County, which had legal custody of the plaintiff. So these records that were requested were determinative records in that if you get the foster care file, you know all the parties involved in the provision of foster care. So to the extent there are unknown parties, they would be revealed in the foster care records. So that's what plaintiff was trying to do here, and that's what the plaintiff was trying to do in AS. It's the same. Opposing counsel focuses on a difference in language at one point in the 428.8 request. I note that in this case, the letter request, it said, kindly contact me immediately if your office is unable to comply with the enclosed request or cannot comply within 30 days from the date of this correspondence. And in fact, Erie County responded in relatively short term that they didn't have the records. Did the same thing in the AS case. But it's Erie County's obligation as the custodial entity to locate the records and respond to the request. They effectively have custody and control of the records. And to the extent that they have delegated to a contracting agency foster care, they need to have access to those records and produce them pursuant to a request that's in accordance with the regulation. So there's no material difference between the diligence that was exercised here and the diligence that was exercised in AS. The long and the short of it is that the plaintiff in both cases was trying to identify any unknown party involved in the plaintiff's foster care and exercise diligence prior to the expiration of the statute of limitations in doing so, and therefore CPLR 1024 should apply. Unless you have questions regarding CPLR 1024, again, alternatively, we've raised CPLR 203 on the basis of the contracting agency CFS and Erie County being united in interest. CFS is an alternative. CPLR 203 is an alternative. In the AS case, that alternative was not reached because 1024 is satisfied. I think the same is the case here, but if you were to reach CPLR 203 and the questions raised there, that statute would apply as well and allow this claim to be brought.
Thank you, counsel.
Thank you.
Case 292, Union Springs Central School District versus Norbut Solar Farms LLC. Proceed, counsel.
Good morning, judges. Stacey Maris, attorney with Costello, Cooney, and Fearon for Union Springs Central School District. I just want to start out by saying that this is a very simple case that's before you. It involves a refined solar developer in the regular business of developing and constructing solar energy systems, in the regular business and regular practice of sending these notices to construct and should be aware of the requirements of 487-9A, and a small rural public school district in a poorer county in upstate New York, that is Union Springs Central School District.
I have a question just about the record.
Yes.
In terms of looking at the label on page 48,
yes,
the return address label, I didn't see anything on the label that referenced the word superintendent.
Exactly.
You do see it, as you mentioned, in the salutation in the letter,
yes,
Superintendent Dennis, and then we get into all of that. My concern is that the complaint, on page 32 of the complaint, it seems to reflect that the school district was well aware that the letter was to be sent to the superintendent, maybe because the recipient opened it and saw the citation. Maybe it's as simple as that, but I'm not exactly sure why, but it seemed to be very clear that they knew immediately upon receipt on February 7th that it was to go to the superintendent, just that the superintendent was misnamed. Am I reading the record wrong?
No, Judge, so it's not the fact that there wasn't a superintendent salutation. It is the fact that it was the wrong party named, and then therefore is not the highest ranking official in the taxing jurisdiction.
Because it's the wrong official. You're not arguing
Correct.
that superintendent isn't the highest titled official.
Correct, Judge.
You're just saying it's the name itself, the surname is wrong, and that's enough.
Yes, Judge, and we will rely on our papers for those arguments as to why strict compliance with the language in 487-9A is required, which includes the right name to be named. I'm not going to run through all the case law that is presented in our briefs for that, but I do also want to just point you in the direction in the record that the letter itself and on the certified mail label, nowhere on that appears the superintendent, let alone any superintendent. It does not name the superintendent. It is in a salutation that the wrong party is named.
Let me ask you this, Counselor. If the letter itself, everything else is the same, but the letter itself simply said superintendent without providing name, would that be satisfactory under your theory?
I would say no.
Why?
Because, per our arguments in our briefs, that it requires the highest ranking official of the taxing jurisdiction. So it is the burden on the developer to know who that is and to send it directly to them, exactly to avoid,
name.
Yes.
So in other words, just to slow you down for my sake, you would say it has to be addressed specifically by name to the superintendent, whoever occupies that singular spot.
Yes, Judge, exactly for the reasons in the paper that it could lead to an absurd result, that exactly what could happen here, it may not get to that person necessarily. And, or not saying that this is what Norbert did, but it could be naming an incorrect party. And in that sense, naming an incorrect party in the sense that they use the wrong name entirely, like here, Superintendent Dennis.
Let me try to pin you down further. If it said on the letter, please deliver to the superintendent, but didn't give the name, you're still saying that would be not in compliance with the law?
In theory, that could be clearer, and we would be in a different position here, perhaps, but with a strict compliance of a notice statute that is required, I would argue no. And so unless the judges have any more questions, I will reserve 5 minutes for rebuttal if needed.
There's no reserve rebuttal here.
Okay. All right. Thank you, Judge.
Thank you, Counsel.
Good morning, Your Honors. Eric Ferrante for the respondent, Norbert Solar. I will agree with opposing counsel on one point. This is a straightforward and pretty simple case. There's really one issue here, and I think that comes through relatively clearly, I hope, in our brief. The trial court found that RPTL 487-9A requires substantial and not strict compliance, and I think the resolution of this case really turns on whether the trial court got that right, and we submit that it did. There's nothing in the statute that requires or says that it must strictly comply. There's nothing to the question that was asked a few moments ago about whether you need to specifically name the exact superintendent. There's nothing in the statute that says it needs to be sent to the highest ranking official by name. The statute simply requires that the notice be sent to the highest ranking official. And the letter here, there's no dispute with the exception of this naming issue, including all the language that the statute RPTL 487-9A requires be included in a notice of intent to construct a solar farm, and was sent to the superintendent. Yes?
Your argument, counsel, would be if it was addressed, dear highest ranking official of the taxing jurisdiction, you would say that's strict compliance with the statute, that would count, right?
That would, I think the question was if it was sent to superintendent.
But what if you simply described it exactly out of the statute? Would that be good enough?
I think that would be good enough. I think better would be.
The argument is they got it, but it wasn't addressed there, but you really needed the name. Do you have any case law for the authority that you really need the name of the specific highest position?
Well, so that's not our argument is not that you need the name. So as I understand the school district's argument,
My only question was, have you found any cases that requires the name itself? I have not, but in case you did, I want to...
No, I think both parties agree. I mean, this is a relatively new statute, and it was amended. This language that includes sort of what the notice is to require was added in 2021. And as the court might imagine, this is not a situation that comes up that often because there's only so many.
Counselor, if I may, let me follow that question. If the notice said, deliver this to the superintendent, then whoever opened that envelope would know, I got to walk this down the hall and give it to the superintendent.
Right.
But I think the argument here is that by putting the wrong name on it, the person who opened the envelope didn't know what to do with it.
I agree, that's their argument.
Right. And so there's a difference here in terms of a mistake which might be insignificant and then correctable at the time, or a mistake that leads people to make another mistake and not deliver it to the superintendent. And that's the point. Like, how do we know what happened here? How do we know how the person who opens the envelope that is misidentified, how are they to determine whether to walk it to the superintendent or maybe this looks like junk mail, I'll get rid of it?
So I think I don't think it's relevant what the person that received the letter did. Ultimately, the question is the error, and we'll concede naming the wrong superintendent was an error.
Well, the purpose of the statute is to put the school district and vis-a-vis the superintendent on notice that this is happening and you may need to take some action. And if the letter is drafted in a way that doesn't give the person who literally opens it the understanding I've got to deliver this to, because we don't know how many letters are delivered each and every day to the superintendent.
Right. But I think this letter, and if you look at it, it's pretty clearly not junk mail. It's addressed to the school or to the school district at the district's main offices. It indicates it's for the superintendent, and it includes pretty clear notification that this is a legal matter. This relates to taxation. This relates to the construction of a solar project. I think.
I'm sorry, I don't interrupt you. That's their very point, though. It's so important that you have to do it right.
But the law is clear in these sorts of situations that where there's a notice statute, so long as the notice that is provided is not drafted in such a way, or the error is drafted in such a way so as to misrepresent sort of the terms of the notice or create or be deceptive. I don't think any of that was the case here. I think this letter satisfied all the requirements of 487 and was indicated that it was for the superintendent. I think the fact that it had the wrong surname doesn't defeat the fact that it said it was for the superintendent. It was sent to the school district's main business office where that superintendent conducts their business and should have been delivered to the superintendent. The fact that it wasn't, all that means is that the district failed to satisfy the 60-day deadline to respond. But it was delivered in accordance with the real property tax law. It was included the language that it was required to include, and it was directed to the superintendent. I think
Well, that's really the issue before us. In other words, you both started your argument the same way. This is really kind of a simple one-issue case. Is the name Dennis, is that misleading enough to not comply with the statute, or is superintendent enough? And that's for us to grapple with, isn't it?
I think that's correct, yes.
Thank
There's
you.
just one more point, if I may.
Sure, briefly.
And I'll make it very brief. There's a reference in the school district's brief where they asked the court to overturn the trial court, which of course we believe the court should not do, and to issue a declaration that that the notice was not sufficient and that Norbert Solar is therefore not exempt from real property taxation. And I'd submit that while the court, if it were to overturn the trial court, certainly can enter a declaration that the notice was insufficient, I don't believe that there's anything in real property tax law that will allow this court to take the next step to say, and therefore Norbert is not entitled to the real property tax exemption included in 487. Instead, all that would require, if this notice was insufficient, is that there be negotiations for a pilot agreement. The law is very clear that solar energy projects are exempt from real property taxation. Local taxing jurisdictions can act to remove that exemption. It's undisputed the school district did not do that here. And so all that a decision that reverses the trial court would require the parties to enter into pilot negotiations. But of course, we don't believe that's necessary. We think this notice was sufficient.
Thank you, Counsel.
Thank you, Your Honor.
Case 295, U.S. Bank National Association versus Guardian Preservation, LLC.
We have her, Judge. She's just taking a moment to come in.
That's okay. Thank you. Counsel Standish, can you hear us?
Good morning, Your Honors. I can hear you.
And we can hear you loud and clear. Please proceed.
Claire Standish from Hinshaw and Culbertson for Plaintiff Respondent. Respondent rests on its brief unless the court has any specific questions.
No questions, Counsel. Thank you.
Thank you.
Case 297, Santa Bria versus SJ Trans, Inc. Counsel Harris, can you hear us?
Thank you, Your Honor.
And we can hear you. Very good. Counsel, proceed.
Good morning, Your Honors. John Ryan on behalf of the plaintiff appellant Tierra Santa Bria. Your Honors, two issues here. First issue, no compliance with CPLR 3121, so there was never actually any notice for a physical examination. Second issue is that the defendants here did not satisfy their burden of showing the necessity of 3 medical examinations. Just going right to CPLR 3121, it's shall language for the time, the physician, the conditions and scope of the examination and location. None of that was done here.
Counselor, I mean, didn't you or your firm start the ball rolling by sending out the initial notice?
We absolutely did.
And then under the rule, wasn't the defendant really simply required, and as well as under the terms of your notice, to provide the name of the physician to examine your client?
Your Honor, forgive me, I don't think that issue was raised below in opposition.
Right, but the issue here is whether or not, I mean, as I take you, your point is, the motion itself, the motion to compel was defective because they didn't initially comply with 3221 or 3121.
They never complied, that's correct.
They never complied, but you served the notice. Or your firm served the notice.
Oh, I understand the notice fixing time for 30 to 60 days notification of the physical examination. So I would say in response to that, Your Honor, I'm not aware of anything where our notice under 22 NYCRR 20217 removes the obligation for CPLR 3121.
Yeah, it's just that your notice said, pursuant to 20217A, within 5 days, submit the name of the physician that you want to examine the plaintiff.
Yeah, and it wasn't done in 5 days either, so I guess the counter argument would be if there's no compliance with that, then technically they're barred from any physical examinations. You know, and I apologize, Your Honor, but I've never had that issue before or been asked about that issue. I really do believe, though, that the reg can't extinguish what the CPLR requires you to do for notice for physical examination. Physical examination is compulsory, right? You have
Counsel, let me ask you a question about that. So if the procedure was when you sent out your notice for exam, that the only response required to that was to respond that here are the names of the doctor, or the doctor or doctors that we want to examine the plaintiff. What does the statute or the reg tell us about what's next?
Yeah, so then what's next is we have 10 days to respond with any sort of objection to the names that are listed.
And therein lies maybe the problem, because if in fact the response to you was, here are the doctors pursuant to the reg that we want to examine, have the plaintiff examined by, is there no burden on you to respond to that, as opposed to what appears to happen here is you go back to saying, hold on a second, they didn't satisfy the CPL requirement by giving us a place and a time for the examination. Do I understand that correctly?
Yes, Your Honor. The only thing I would say as a caveat to what you just presented is there's nothing in the record saying we didn't respond within 10 days, right? And I think that that's the other issue is in these moving papers, there's not a single email, there's not a single notice, there's nothing that says that they did respond to our request for a notice fixing time. There's nothing that says that we were not timely in objecting. But you didn't, see, that's the problem I'm having with this, and I don't know that I've ever encountered this, frankly. Yeah. So
Your notice didn't fix the time, the place, or the doctors, nor could it.
That's correct.
Right? And so once your notice went out, we're reading both the statute and the reg together to work together. That's one of the things we're required to do if we can do it, right? And so once your notice goes out, there's an obligation on the part of the defendant to provide names of the doctors that they want to examine, right? That puts you on notice, here are the doctors. That gives you some information.
That's correct.
But it doesn't set a date, time, and place. You haven't set it, nor have they set it. Who has to set it?
Yeah, then I think it just goes to court discretion, right? Because the other thing is that I'm sure Your Honor is aware of from your time down at the trial bench is that we send these notice fixing times and they always get trumped by the scheduling order, right? It goes back to the judge's discretion. And again, I think it goes back to the language of we may send this, right? We may do this, whereas with CPLR 3121, it's you shall provide notice of these different items, right? And then the other thing that I would say, Your Honor, is, you know, I'm not going to sit here and say, you know, we didn't even raise it in our appeal that they should be barred because of our 20217 notice fixing time. I think that's in the court's discretion to say that there's good reason to allow both sides to litigate this case to the fullest extent, right? I don't think anyone's here trying to ask for a hard deadline for anything else like that. It's just simply with this issue, CPLR wasn't complied with. You know, in the situation that Judge Del Conte raised, if you're saying that that notice fixing time limits us to only the names presented, then my response is, in response, we can say, okay, thank you for the names presented. Now please comply with CPLR 3121. That's our objection. In addition, it's clear, I think, that the objection is that you are requesting 3 medical exams. Please provide your basis for that. And there was no basis. And that goes to that second prompt.
But the trial court has a lot of discretion in terms of that. They're the gatekeepers with respect to this, right? And the trial court has an ability to look at this and make a judgment call as to whether that third, it doesn't seem like there's much of an argument that the first 2 doctors would be appropriate here. It seems to me in reading the papers, your argument on the third is that shouldn't be allowed, and there hasn't been a substantial showing that it's necessary. I think you mentioned that the plaintiff was never treated by that specialty.
Never treated.
Right, and so why would they be entitled to that examination? That's your argument. I know they have an opposing view of that. But isn't that a trial court's discretionary call?
So the actual determination of whether or not the necessity had been established by the moving party, I agree with you. That is absolutely trial court discretion. However, compliance with the CPLR, that part, if you're not complying with CPLR, that is an abuse of discretion.
All right, so we're back to point 1, really.
Well, just because Your Honor, it's tough because they're contingent upon one another, right? Like that's the issue here, is that you're saying that you want these exams, but you're not telling us the date, time, scope, and what's going to be done in the exam. And so back to Your Honor's first point, I think we absolutely concede that the orthopedic surgeon is someone that they're entitled to do. She treated with an orthopedic surgeon, she had the surgery. We're not contending that. But then she has a brain injury, right? She's never treated with a neuropsych. To my knowledge, she's never treated with a counselor or psychiatrist. And so now they're saying we need a neurologist and a neuropsych. Well, cumulative, right off the bat, because you haven't established what each person is going to do differently. In the cases that I've read from this court, one case that we didn't cite in our brief, but there's a case called Pekarski where a neuropsych was allowed. Medical affidavit from the neuropsych saying exactly why this is necessary and why a neurologist isn't necessary. That person treated with neuropsychs, that person had counseling and psychiatric exams as well. And so the real issue here is, why is the neuropsych necessary when she's treating with the neurologist, and only treated with a neurologist?
But that issue was before the trial court.
I think, so the issue was before the trial court about the amount of the exams.
And the specialties.
And the specialties, but not the scope or the conduct of the examination, which is what I think is the real crux of this issue, right? In your honors, I think you're starting.
Let me ask you, counsel, so if we were to affirm the trial court, are you saying that because the scope of the exam has not been established, that there'd be a further application below to the trial court to limit the scope of the exam?
Yeah, that's completely possible, Your Honor. And, it's not trying to be difficult or anything else like that. It's just without compliance with the CPLR, at least the cases I read, that for Francisco V. Vasquez case, there is no actual notice and we have no ability to comply with that, right? But then going to specifically with the neuropsych cases, Your Honor, I think you all are starting to see this more and more often, and if you're not, it's coming. The neuropsych issues are being litigated heavily down below. And we have, I know you all have seen a case, it's called Manor, I believe, where they specifically tried to enter into an agreement where the neuropsychs actually produced their raw data, and all of them literally said they would not. And so then this court said, because none of them will examine the plaintiff, if they have to present raw data, then we will allow this to go forward, but we are not precluding the plaintiff to get that data later. There are things that neuropsychs control with these exams that is unlike anything else, because it's their actual subjective belief of what the plaintiffs say, and we can't record them. And right now we're having trouble getting what the raw data is. No other expert gets that allowance. The other thing I will say too, as I was thinking about this last night, is if you grant the neuropsych, right, and the neuropsych does this exam, she's never treated with a neuropsych, never did anything with the neuropsych gets to go in addition to the neurologist. The neuropsych says, this is my raw data, regular physicians can't interpret this. You're almost compelling us to hire our own expert as a neuropsych, right? Just to be able to combat what their neuropsych is saying. And again, that goes outside the scope of what her actual treatment is.
That's a very interesting argument, but you didn't make a motion below, a motion for a protective order or any other type of limitation. As I understand, the argument below was these injuries don't qualify for the neuropsych exam when the court below said, well, your client testified to the traumatic brain injury, so she, and that was a discretionary call.
Yeah, I understand, Judge.
So the point is, you're not precluded at this point from moving for a protective order, because that examination hasn't taken place with Dr. DiBenedetto, has it?
That has not taken place. That's right. There's a stay in order for this court to decide on the issue in front of it today. But again, you're asking why we didn't make a protective order in some ways. Sorry, not to put words in your mouth, Your Honor. But it's because we didn't have notice of what's
right. But that's where I'm having a problem with this case, because it seems like your office started this ball rolling by sending out the notice. You get yourself into this situation where your notice itself says to the defense, all you need to do is send us the name of the doctors. And then you're having a short discussion about it 5 days later, 4 days later, you're in front of the judge fighting over this. And you take a position here, well, the court didn't have any jurisdiction because they didn't serve the notice when you did. And now we're into the substantive argument of whether the court abused the discretion or not, and there isn't a lot in the record about this. And you didn't move and you didn't make many of these arguments that you're making now as to that this was improper.
Yeah, and so, Your Honor, I would just say we absolutely did burden on issue 1 that I'm presenting to you, burden on issue 2, right? This is a burden case all day for that, for those arguments below. The other thing I'm going to return to again is I'm not sure where following the reg excuses non-compliance with the CPLR provision, right? And if you are, I see what you're saying with this, like, it's almost like pot calling kettle black situation with this. And the other thing is we want these things to move. We don't want motions for IMEs and everything else like that. It's just, this is the situation because there's 3. And again, I'm not aware of anything that through the reg excuses compliance with the CPLR provision.
It may just be a construct of the CPLR interplay with the reg and how they're being interpreted, which is what's being put before us. And so the confusion that maybe both sides are having with what's next after they comply with the regulation and provide the names of the treating or the examining doctors, what's next and who has the burden to take that next step? You're saying they do, and they needed to notify you of the time and the place of that examination. I think your opponent's going to disagree. So anyway, I think we have that argument.
Yeah, and just briefly, Your Honor, with regards to the time and place and conduct of the examination, we have no ability to make them do that. We can't schedule their experts or anything else with that, which is why if you're reviewing that question, I would just ask you again to go back to the CPLR and think about practically how this would happen to be scheduled as well. Thank you, Your Honor, for your time.
Thank you, Counsel. Counsel Harris, please proceed.
Your Honor, as a preliminary matter, this issue of the notice, I think, is largely pretextual. Certainly, there are instances where various provisions of the CPLR are relaxed in order to ensure that there's a just and fair outcome. What we haven't heard, presuming that there was a notice issue, is that there was any meaningful or incurable prejudice to the plaintiff as a result of this supposed notice issue. When we notified the plaintiff that we wanted to have the plaintiff seen by Dr. Benedetto, we didn't receive any objection predicated upon the fact that improper notice was provided. In fact, we didn't hear anything from the plaintiff about that issue until the initial motion was filed. And when we argued the motion below, we indicated that if that was the singular issue that was hanging up, that we could serve a notice compliant with the CPLR, although our position was we weren't required to do so since the plaintiff had already filed the notice herself. But more importantly, I think that ultimately what we're arguing about is the substantial justice and the right of the defendants to determine the scope of their defenses and identify appropriate experts. The plaintiff has conceded that she's making a claim for a traumatic brain injury. And based on the arguments of counsel, it's self-evident that a neurologist and a neuropsychologist do 2 very different things, because a neurologist does not perform neuropsychological testing. And all of the comments made by counsel relative to raw data and things of that nature, he specifically predicated that his concerns with that type of issue on the fact that a neuropsychologist is the only doctor that performs work where his raw data is subject to discovery or is relevant in any way.
Counsel, I think we understand that. I'd like to go back just briefly to the first argument on notice and ask you, once you supplied the names of the doctors, would you agree that it is your office and the doctors, working with the doctors, you are the ones that have the ability to pick a time and a date that works for the doctor and to put plaintiff on notify plaintiff as to what that time, date, and place is?
Yes, and ultimately my office did that, although we may not have done it within 5 days. Certainly the plaintiff was given notice of when the doctor could see her and his location. And in fact, we negotiated about transportation to these examinations to coordinate them with the plaintiff and make it as convenient as it could be for her. So again, the issue is really artificial, because it's not as if any of the notices were denied the plaintiff. If the only issue that exists is one of potentially timing.
Okay, very good. Anything further, counsel?
No, Your Honor.
Thank you, counsel. Case 296, Justice Del Conte is recused. Mertz versus Erie and Niagara Insurance. Counsel, can you hear us?
Yes, Your Honor. Christine
We-
Celeste. Oh,
And
apologies.
that's okay, we can hear you. Please proceed with your argument.
Christine Celeste for plaintiff respondent. Unless the court has any questions, I would rest on my papers and ask that the court affirm the lower court's decision.
Thank you, counsel.
Thank you.